Members, good morning. It's the appointed time. We have a quorum. The administration representatives have come in. I call to order the meeting of the Bills Committee on Stablecoins Bill. Let's continue with the scrutiny. In the scrutiny of the Stablecoins Bill, the U.S. is scrutinizing their stablecoin bill as well, so we'll have to draw reference from the progress. On the 13th of March, they held a meeting in relation to stablecoins. I sought advice from lawyers in relation to their progress. I've provided 2 documents for members' reference. I believe we are not going to dive into these 2 documents, but they're for your reference anyway. Let's start with the administration's response to issues raised at the meeting on the 25th of February 2025. Could you please take us through the paper? Thank you. At the meeting on the 25th of February 2025, members raised some views, and we have already issued a response in relation to these views, and I will walk members through our response. Issue A: whether there is existing legislation in Hong Kong regulating the tokenized transactions of RWA real-world assets. We will continue to adopt the principle of same activity, same risk, and same regulation. The existing legal and regulatory requirements governing the traditional securities market will continue to apply to relevant tokenized securities. Circulars have been issued by the Monetary Authority and the SFC Securities and Futures Commission. Issue B: whether the administration has any plans or measures to attract major global stablecoin issuers. We have been actively engaging with market participants, including existing and potential stablecoin issuers, as we develop the regulatory regime for stablecoin issuers in Hong Kong. We welcome applications from both existing and potential stablecoin issuers, but it is the commercial decision of issuers ultimately. We will process each license application in a fair and consistent manner. We will also encourage existing and potential stablecoin issuers to engage in early discussion with the Monetary Authority regarding their plans for license applications. Issue C: regarding Clause 32 temporary suspension of license and Clause 33 suspension of license of the bill. Members asked about the applicability and their interrelation. We have explained in our response. In formulating the relevant provisions, we've drawn reference from the Payment Systems and Stored Value Facilities Ordinance Cap 584 and the Banking Ordinance Cap 155. The MA is empowered to temporarily suspend a license or authorization for a period not exceeding 14 days. Regarding issue C2, we touched upon invoking clauses 32 and 33. The MA may exercise either of the powers under Clause 32 and Clause 33 of the bill, or exercise both powers sequentially. In other words, the MA may exercise the imposition of a temporary suspension followed by a suspension afterwards. Let's move on to C(3). Members asked the administration how the monetary authority will, upon suspension of the license of specified stablecoin issuers by invoking the two clauses, deal with the stablecoins held by the stablecoin holders concerned. Upon exercising the power to suspend under Clause 33 of the bill, the MA will give directions on the handling of the reserve assets in respect of the relevant specified stablecoins. Please refer to Clause 33, Bracket 3D. And in accordance with Clause 34, Bracket 4 of the bill, non-compliance with such directions will constitute an offense. Moving on to Bracket D. In relation to paragraph 14, the licensee engages in a business practice that would be likely to affect the interests of Hong Kong as an international financial center as one of the grounds for revocation of license under Schedule 4 to the bill. Members asked whether we would consider expanding the scope of the regulation to cover licensees in their regions. Our response is that the MA intends to issue and publish in the Gazette guidelines under Clause 170 of the bill to set out the MA's regulatory expectation of a license, engagement with third-party entities, including its agents and service providers. The licensee should ensure that its arrangements with any third-party entity will not compromise its obligations under the bill in respect of ensuring prudence and soundness of its operations. We consider it proper to keep the existing formulation of paragraph 14 of Schedule 4 to the bill. Any business practice of a licensee which threatens the interests of the holders or potential holders of any specified stablecoins connected with license, regardless of whether such business practice is attributed to the licensee or its arrangements with third-party entities, would constitute a ground for the MA to revoke the license pursuant to paragraph 13 of Schedule 4 to the bill. And moving on to whether the administration would consider including the penalties in respect of regulating the business practices of specified stablecoins in other related ordinances so as to regulate the business practices in a more comprehensive manner. We believe that the bill already provides sufficient mechanisms to deter licensees from engaging in business practices that affect the interests of Hong Kong as an international financial center or threaten the interests of holders or potential holders of specified stablecoins. Engaging in such business practices will potentially constitute a ground for the MA to suspend or revoke the licensee's license under Schedule 4 to the bill. So the bill has already empowered the MA to effect suspension or revocation. We don't consider it necessary to make further amendments. And the members asked whether we would consider improving the drafting of the Chinese heading of Clause 12 of the bill. We are reviewing the drafting of the heading of Clause 12 of the bill. We'll consider proposing committee stage amendments as appropriate. Moving on to issue F, members on the last occasion asked whether we would consider incorporating in Clause 25 of the bill that its duty to report inability to meet obligations, objective factors in determining the presence of reasonable excuse as required under Clause 25, Bracket 2, in order to avoid a merely subjective decision by the licensee as to whether or not to take the actions required under Clause 25, Bracket 1, or a deliberate attempt to circumvent the obligations imposed on the licensee under Clause 25. We've considered members' views. We've also drawn reference from similar provisions in the PSS VFO and the banking ordinance. We will propose a committee stage amendment such that the reporting obligation in Clause 25, Bracket 1 is triggered simply if any of the relevant circumstances arises, that is, the licensee is likely to become unable to meet his obligation, is insolvent, or is about to suspend payment. the aim is to reduce the element of subjectiveness. Thank you. That concludes my response. I now open the floor for members to ask questions on the administration's response. Do members have any questions? Please press the button if you do. All right, Ms. Carmen Can. Thank you, Chairman. In relation to issue D of the response, that is Schedule 4 to the bill, under what circumstances will the administration consider revoking the license of the issuers? What factors will be taken into consideration? In paragraph 14, if the business practice is likely to affect the interests of Hong Kong as an international financial center, this targets the activities undertaken by the licensee. In English, it is engaging in a business practice. Dr. Johnny Ng and I said that stablecoins themselves are neutral. They are a medium. It depends on how the licensee uses stablecoins, say in relation to payment, transaction or settlement of transaction, investments, and so on. The issuers of stablecoins don't know what the issuer of the stablecoins will do in the future. In other words, if it is used in the illegal market, there is no control over such activities. What can the MA do to curb such activities? That is the background of the discussion in this regard. That's exactly why we asked whether the administration would consider expanding the scope of the regulation to cover licensees and their agents, among others. And I just provided the background of the discussion. Say when the stablecoins are used in illegal transactions, when stablecoins are used in illegal transactions or in the illicit market, that is the background of our discussion. However, in the government's response, the administration invoked paragraph 13 of Schedule 4 to the bill. I think this is wide enough. Any business practice of a licensee which threatens the interests of the holders or potential holders of any specified stablecoins connected with the license, regardless of whether such business practice is attributed to the licensee or is arrangements with third-party entities, would constitute a ground for the MA to revoke the license pursuant to the relevant provision. Once this is spread in the community, the MA needs to have the power to revoke the license. Well, the answer isn't directly related to our discussion, but then the administration pointed out paragraph 13, and I believe this is wide enough. Thank you. Any response from the administration? No response? All right. So members' concerns have been addressed. Mr. Adrian Ho. Thank you, Chairman. The government said legislation in relation to securities is applicable to stablecoins. What about non-security entities such as real-world assets, for example, antiques and artifacts? Will they be explicitly covered under the regulation scope? My next question is, in our previous discussion, we mentioned attracting international issuers to come to Hong Kong to apply for licenses. The administration's response covered this area, but there's a lack of concrete measures. Is there any concrete measure being prepared by the administration in relation to attracting international issuers to Hong Kong? Well, Ms. Adrian Ho, we are talking about the administration's response. Your first question is in relation to issue A. When it comes to attracting international issuers to Hong Kong, issue B.
And for C, last time members were concerned about clauses 32 and 33 and wanted to have more concrete examples. I don't think that there are enough examples here that we might need to use some of the reserve fund for issuance. I want to know that if the license is revoked, how can the monetary authority and government ensure that the stablecoin holder can recover this asset? Would there actually be a third-party trust as a contingency plan? And under issue D, to ensure that the third-party partner must actually be in compliance with the law, but if the agents violate or breaches the law, then the license holder might also need to take responsibility. What are some of the measures the MA can do to ensure that there would also be third-party compliance? Thank you for your questions. On issue A, tokenized transactions. We keep up with the consistent principle of same activity, same risk, and same regulation. For transactions such as artwork, this is not under our ambit at the moment. We are working on virtual asset policy statement and our vision for VAs. And when the occasion is appropriate, then we would give more information on how to regulate tokenized transactions. And now I'd like to defer to the HAMA to address issue B. Ernest. B. Yes. That's how to attract major global stablecoin issuers. We have been actively engaging with major issuers, major market participants, and we are sharing the development of our regulations. I think most importantly, we need to share with others the attractiveness of our regime. As to whether we would directly attract them to set up a company or an office here, then it's up to their own business model, whether they could adhere to our format. And we have engaged with many market participants, and I believe that it is going to be positive because many of them are positive about our environment. Based on their own business model and their use cases, they will decide whether or not to apply for a license under the proposed regulatory regime. Christopher. Thank you. We have stated in Schedule 2 on the reserve fund that the holder must have a trust agreement. The MA will request that there be a third-party trust against an agreement to ensure that the risk could be minimized. Well, when the agent is in breach of the law, Ms. Khan also mentioned that the responsibility may not lie with the holder of the stable coin, but when it is actually an agent that is in breach of the law, then it might affect the stablecoin holder, and therefore the holder might be affected by any behavior of the agent. Ms. Carmen Can, on issue A, Mr. Ho has asked a question on that. I agree that this might not be under the discussion on stablecoins bill. However, last time we talked about the real-world assets regime on how we can regulate it, but I believe that this is undergoing development. In the government's response, we see that the MA and the SFC have all respectively issued circulars on requirements and expectations in relation to tokenized real-world assets. I believe that Web3 committee can discuss that further. This is only an initial mention of the framework of tokenized RWAs. Well, would the USDT or USDC come apply for licenses? And of course, it's up to them. But for holders who are in Hong Kong and who are investors are protected by us, how can we foster the development of this industry in Hong Kong? I hope that the government could provide us with more information on that later. Well, I think we would touch on that when we go through the bill, because I believe that we could carry out further discussions on that later. As for real-world assets transactions, I believe that each country is discussing about tokenized transactions of RWAs. The US is also trying to differentiate what goes under securities. We could not penalize assets that have become tokenized and should. But then, of course, we could discuss this further on a different occasion. Are there any other questions on the responses given by the administration? If not, then we could go back to the scrutiny of the bill. We have completed Division 2. Part 2, Division 2. Now we can go to C3240. On Division 3, we would focus on the Chinese version, and the legal advisor would help us scrutinize the English version. So should we now begin from C3240 of the blue bill? And members can press the speak button whenever they have questions. 4 minutes each for each question. Let us begin from Division 3. Division 3 is on ownership and management of licensee, and so there are 10 subdivisions here. We start from Clause 36, which is on the application of this division. Under bracket 2, it applies in relation to a licensee that is an authorized institution, including Section 63 on the appointment of manager, and on subdivision 7, 8, and 10 on the appointment of stablecoin managers and the hiring of high-level management staff, and also on the authority to request for more information on the appointed managers. And on clause 37, unless a person becomes a controller within 12 months of the day on which a notice consenting to the person becoming such a controller, or if a notice objecting to the person becoming such a controller is given, otherwise the person must not become a controller of a licensee. If there is a breach, then it would constitute an offense. Clause 38 on a MA's consent for a person to become a controller. So this is a consent for becoming controller under Section 37. On receiving an application, the MA may, within a period specified, give consent or an objection and can request the applicant to provide relevant information. Clause 39. A person who becomes controller in other circumstances. The MA can also allow a person to apply if a person becomes controller in other circumstances, but then this applies to a person who becomes aware of the fact that he has become a controller within 14 days, and after such an application is made, a response should be given within 30 days by the MA. Ms. Carmen Ken. Chairman, I have a small suggestion. As we cannot make too much reference from other laws and regulations on stable coins. I hope that the administration can explain further on why for example, a controller could become a controller within 12 months of application. We want to understand the more background information, and I hope that the administration could provide us with that information. Well, thank you, Ms. Khan. We have made reference from the banking ordinance and also the payment systems and stored value facilities ordinance. Perhaps the HKMA can provide more information on the origin of appointment of managers or other relevant information. Thank you, Ms. Khan, for your question. All these clauses have their reference drawn from other previous ordinances. Ms. Khan asked why an applicant must become a controller within 12 months under the consent of the MA. Well, that is because the MA must conduct due diligence to ensure that the applicant is a fit and proper person. And that decision must be made by the MA, which could not be an infinite period, and this period must be within 12 months. And we see under the banking ordinance and the PSSVFO that there is also the same requirement. Well, yes, I know that you have drawn reference from these two ordinances, but then when you are explaining it, you have to tell us why it is related to the stored value facilities, because that is not a coin, and that's not a fiat referenced stable coin. It's just a facility. Therefore, you have to tell us why it is appropriate for a stablecoin issuer and why we are using it, and which part of the banking ordinance are you drawing it from? Because I don't want us to be too strict or too lax on the regulation. Can you share with us your considerations?
Chris, thank you, member, for your review. We've drawn reference from the Banking Ordinance and the PSS VFO. So in Schedule 2 to the bill, we have set out the minimum criteria, which are tailor-made and specific requirements in the context of stablecoins. We believe the controller will have some impact or control over the issuer, so the controller needs to be a fit and proper person. We find it appropriate to draw reference from the Banking Ordinance and the PSS VFO. The EMA has a set of standardized criteria with which the issuers will have to comply. Mr. Adrian Ho, or Dr. Johnny Ng. The special features of stablecoins are that they straddle a lot of different jurisdictions. They aren't unique to Hong Kong. The administration needs to explain clearly why you have drawn reference from these ordinances. What are the indicators that the administration has drawn reference from? Anything else to add? Thank you, Chairman. Thank you, Dr. Johnny Ng. When it comes to the organization design, in circulars or applications, we adopt a top-level design, and we have drawn reference from the ordinances we just now mentioned. When it comes to specific requirements, as colleague of the Hong Kong MA has already said, we need to take into account the special features in different background or in different cases, and we will touch upon these areas in a moment. They are for settlement of transactions, and we'll come to that in a moment. Any question? No, we move on to Clause 40. That is conditions for consent for controller. The MA, monetary authority, needs to send a written consent, and within 1 month, the applicant of the licenses may make a written submission. After the MA considers the written submissions, the MA will consider whether to impose or amend any conditions. Clause 41. Supplementary provisions for objection notice given under Section 38 or 39. Subclause 2. The MA may give an objection notice to the person if the MA considers that any of the following matters is satisfied. Brackets 2a, that the person is not a fit and proper person to become or continue to be such a controller. B, that the interests of the holders or potential holders of any specified stablecoins connected with the license would be or are in any manner threatened by the person becoming or continuing to be such a controller. Let's pause here. Mr. Robert Lee. Thank you, Chairman. We've come to Clause 41, Subclause 2, brackets A. This is the first time we see a fit and proper person, and this is mentioned quite a number of times under the bill, especially in Schedule 2. There will be a more in-depth discussion on fit and proper person. Directors, for example, need to be fit and proper persons as well. This is understandable. This can prevent overly subjective approval. I'd like to know how you define a fit and proper person. Of course, I understand there are hard and fast indicators. In English, we call it fit and proper person. But how do you assess whether a manager, for instance, is a fit and proper person? Are there any guidelines provided in relation to defining a fit and proper person? Then the applicant or the operator will have a better idea. The purpose is to ensure fair treatment towards these parties. Thank you, member, for your question. Well, I'd like to emphasize the process is definitely fair. We take into account different factors. Upon the passage of the bill, we will issue a supervisory guideline which will contain more details, or I can briefly tell you what factors we'll take into account. The MA will take into consideration a lot of different factors, including but not limited to any non-compliance record or any condemnation by regulators, any investigation by the regulator, or any undertaking in relation to supervision or regulation of the issuers, any criminal record, so as you can see, we have a basket of factors. These are objective factors, and we take them into consideration. Well, I suggest upon the passage of the bill, the administration should provide detailed descriptions of these factors. This will ensure a fair treatment for operators and applicants. Ms. Carmen Khan, I have a similar point with Mr. Robert Lee's. We've drawn reference from the banking ordinance, but then stablecoin issuers aren't operating a bank actually. They are not a payment system or stored value facilities operators either. When you issue guidelines, you need to take these factors into full consideration. The definition of controllers is wide as well. In relation to the definition of controllers, it is very wide as well. It means a majority or minority shareholder controller or an indirect controller. So a fit and proper person isn't used in the context of banks. So for clause 36, several subdivisions aren't applicable to banks. Therefore, I hope that the administration will give us more explanation in relation to why this ordinance was used. In other words, why did you take into account CAP 155 and CAP 584? We'll have to consider the appropriateness. Has the administration consulted sandbox operators? Is it possible that they may not submit the applications because they will not be able to fulfill the requirements? Ernest, thank you. In relation to feedback from sandbox operators, We have close liaison with the three operators. We've touched upon the contents of the bill. Regarding the supervisory guidelines, we've compared notes about the preliminary thoughts about the guidelines. We've talked about the comparisons among different jurisdictions. They have, in general, positive feedback. They consider our proposal reasonable. Mr. Ambrose Lam. Thank you. Are there any mechanisms for the person receiving an objection notice to launch an appeal? Do you mean Clause 42? I'm referring to objection notice. That is Clause 42, Clause 3. Well, it should be Clause 45, but we're on Clause 42. Maybe we'll come back to you when we discuss Clause 45, all right? All right, thank you. Thank you, Chairman. Let's move on first. Let's continue with Clause 42. Thank you. Clause 42 empowers the MA to raise objection to existing controllers. The concerns are set out in subclause 2. The factors are similar to those in considering applications. A. That the person is not or is no longer a fit and proper person to be such a controller. Brackets B. That the interests of the holders or potential holders of any specified stablecoins connected with the license may in any manner be threatened by the person being such a controller. Or bracket C. That the person has contravened a condition attached to the consent under Section 40. Clause 42, I have a question. Let's pause right here. My question is similar to Mr. Ambrose Lam's. In Clause 42, subclause 3A, preliminary notice, I'd like to ride on Ms. Carmen Can's suggestion. Is it seen in other ordinances as well? You will only issue a preliminary notice when you object. You will only issue an objection notice when you object to the application. So why do you need to issue another preliminary notice? When you issue a preliminary notice, it means that you are going to object to the application of the notice or the application of the person. Well, this practice is in line with that under Cap 155 and Cap 584. We need to give an opportunity for the person receiving the objection notice to provide written submissions. Clause 42, bracket 3, brackets B. Within 1 month after the date on which the preliminary notice is given, the person may make written representations to the MA as to why an objection notice should not be given. In other words, we provide an opportunity for the applicant to provide written submissions. We'll have to consider the nature of stablecoins as well. Issuers of stablecoins oftentimes don't know what the holders of the stablecoins are going to do. So issuers may not be able to tell you what holders will do. So you need to consider whether it is appropriate to call it a preliminary notice. Ms. Carmen Can. Thank you. My question is about your question as well. Controllers or controllers to be may be considered not eligible. In Clause 40, bracket 6 and Clause 41, bracket 6, the MA is not obliged to disclose to any person the particulars of anything that the MA has considered in giving a preliminary notice or objection notice. Which ordinance have you drawn reference from? If one doesn't know the details, can one still launch an appeal? Or can one still raise any defense? Thank you.
係，多謝主席。
Chris. Thank you, Chairman. Thank you, Ms. Khan, for your question. We have drawn reference from the PSSVFO, which is under 8SSJ. I would like to emphasize that under 42 bracket 3, when the monetary authority gives preliminary notice, it must point out the specified matter. So the person will know why an objection is given. We just want to state out that we do not have the responsibility to disclose the particulars. We would to others. We're just going to let the applicant know. Well, so it can either be A, B, or C under subclause 2. Well, so the person will know that he is no longer considered a fit and proper person. But would that person know whether it is because he has contravened the law or why? Would a reason be given? Would the person know why he is no longer considered to be a controller? Or would that person will only know whether he has contravened a condition or that he is no longer a fit and proper person. But if you say that he is no longer fit and proper, would a reason be provided as to why he is no longer fit and proper? Oh, yes. When it is appropriate, then the MA can include a description as to why an objection is given to the applicant. Let's continue to see whether the mechanism is appropriate. Moving on to clause 43. A licensee to notify monetary authority of change of controller within 14 days. Clause 44 on the interpretation of some of the terms used in subdivision 3, including specified controller, as the term specified controller would be present in other clauses. Clause 45, a prohibition regarding indirect controller. When a person is a prohibited person in respect of a licensee, then that person must give direction to the directors of the licensee. Clause 46 on the restriction regarding specified shares in licensee. For example, the shares could not be transferred. Under clause 46 bracket 1 bracket A, B, C, and D, it talks about how it applies to a specified controller of a licensee. That if a person has become such a specified controller in circumstances other than those described in section 37 bracket 1, which is that it is that the person is not a specified controller agreed by the MA. B, the person is a person to whom Section 39 applies but has not made an application under Section 39 bracket 2, which refers to a person who is not aware of becoming a controller. And that he has not raised this to the MA within 14 days. Clause 47. On revocation of notice in case of person mentioned in Section 46 bracket 1 bracket B. Well, as we mentioned earlier, 46 1B, when a person is not aware of being a controller and he has not made an application within 14 days. And on clause 48, on the effect of restriction mentioned in section 46, bracket 2, bracket 1, if any specified shares are subject to restriction mentioned in section 46, bracket 2, bracket A, then agreements are void when which means agreements on transferring shares, and that if those shares are unissued shares, an agreement to transfer the right to be issued with those shares. Clause 49 on offenses regarding restriction mentioned in section 46, bracket 2. A person who has contravened these restrictions will be liable to offense. Bracket 4 refers to an officer of the licensee or the body corporate who knowingly and willfully permits the issue of shares or the making of such a payment is deemed to have committed an offense. Clauses 50, 51, 51, and 52 on court orders regarding sales of specified shares. Under clause 50, bracket 1, the court of first instance can, on the application of the monetary authority, make an order for the sale of specified shares of a specified controller to whom section 46 applies, and can also make an order that those shares cease to be subject to that restriction under 46, bracket 2. Clause 51. For any specified shares that are subject to a restriction mentioned in section 46, bracket 2, then persons affected by the restriction can apply to the court of first instance for an order under section 50, bracket 1. The monetary authority, after receiving the application or within 1 month of receiving the application, must either comply with the request or, as under 2B, give a written notice to the person making the request stating why this person should not be making such an application, or under C, give a written notice to the person making the request stating that the monetary authority will not apply. Clause 52. Court order regarding sale of specified shares on application of person affected by restriction. The court order can include any specified shares that are sold under an order made under this section, unless the court of first instance otherwise specifies. Otherwise, the proceeds of the sale less the cost of the sale are to be paid into court for the benefit of the persons beneficially interested in them. Bracket 6, a further explanation that the court of first instance can, on the application of a person mentioned in subsection bracket 5, may make an order that the whole or part of the amount paid into court under that subsection be paid to the person. Moving on to subdivision 4 on the appointment of the chief executive. So this would include clauses 53 to 57. We have also drawn reference from the Banking Ordinance and the Payment Systems and Stored Value Facilities Ordinance. Under clause 53, it is stated that a licensee must appoint a person as the chief executive and at least one person to be an alternate chief executive. A licensee must not appoint a person under subsection bracket 1 without the MA's consent given under section 54. When there are vacancies, the licensee must apply to the monetary authority that the monetary authority must agree that there should be an appointment to fill the vacancy. And clause 54 for the consent for appointing chief executive or alternate chief executive. The monetary authority can give consent or to request more conditions. The monetary authority must consider whether this is an individual who is ordinarily resident in Hong Kong and whether this person is a fit or proper person to be a chief executive or alternate chief executive. And the MA can require written notice to be given on more information on that person. Clause 55, conditions for consent to be appointed as chief executive or alternate chief executive. As mentioned earlier, similar to specified controller, the monetary authority may consider whether the person has the intent to apply for this position and whether any additional conditions would be imposed. And the person can provide a written submission within 7 days, and the MA can then decide on whether further conditions need to be imposed. Clause like you to take us through clause 57 before we ask our questions. Clause 56. The monetary authority may withdraw a consent on the appointment of a chief executive. Clause 57. If a licensee becomes aware that a person has ceased to be the chief executive or an alternate chief executive, the licensee must within 14 days give a written notice of that fact to the MA. Ms. Carmen Ken, thank you. Also, you've taken us through subdivision 3 in a general manner. You did not take us through each subsection, but that is all right. Now you have a specified controller to be defined as a majority controller and a minority shareholder controller. And then under clause 45, the indirect controller is in a separate category. So what are the considerations for doing that? Chairman, I think the administration should explain to us the considerations on the clauses. Well, here you have divided the controllers into 2 categories. So can you tell us what the differences are? And on the specified shares, so when an objection is given, then you would impose a restriction. We want to know or understand the considerations behind those decisions. Chris. Thank you, Chairman. Thank you, Ms. Khan, for your question. Let me first explain why we are dividing the controllers into 2 types under subdivision 3. Well, Ms. Khan asked about the indirect controller. If I could refer you to the definition of indirect controller, an indirect controller does not directly hold shares. It's just that this indirect controller would need to follow the instructions given by the shareholders, and therefore we need to divide these controllers into two types. The MA can impose restrictions because indirect controllers do not hold any shares, and so if you look to clause 46, clause 46 is on specified shares in license. So this would only be applicable to majority shareholders and minority shareholder controllers. Other considerations on why the MA can impose restrictions on specified shares. It is because the MA, after due diligence, may deem the controller not to be a fit and proper person. The controller would have a certain impact on the company, and therefore the MA can impose restrictions specifying that the shares are not to be sold to ensure that there would be minimal disruption to the company.
Mr. Ambrose Lam, I'd like to go back to subdivision 3. Making written representations within 14 days after receiving the preliminary notice. Well, later on we'll come to that. In Part 7, we are going to set up a tribunal, and in Clause 140, it sets out referrals to the tribunal for review. Clause 140, brackets 1. A person who is aggrieved by a specified decision may refer the decision to the tribunal for review, and we will come to this when we come to Clause 140. Well, later on we'll come to the discussion of stablecoin manager. And this person can be the same person as the chief executive or the alternate chief executive. Can these positions be held by the same person? Well, these provisions aren't applicable to authorized institutions. When an institution wants to appoint a chief executive or an alternate chief executive, and just now you mentioned stablecoin manager, which we'll come to later on, it is only applicable to non-authorized institution applicants or licensees. And the main reason we have to provide two different functional titles is it within a bank, that is within an authorized institution. In accordance with the banking ordinance, a chief executive has already been appointed. But if one wants to start an issuing business, the MA considers that there needs to be a specific person to be responsible for this business. And under this bill, we call that person the stablecoin manager. Alright, subdivision 4, no question. Let's move on to subdivision 5. Is about directors. Just now, members asked about the policy considerations of each subdivision. And I will ask the MA to provide a detailed background of the subdivision. Clause 58 provides that a person must not become a director of licensee without the consent of the MA. If a person has become a director of licensee or acts without the MA's consent, one will breach the ordinance. Clause 59, consent for becoming director. It provides for the procedure relating to the giving of the consent. The MA can give consent or refuse to give consent. In clause 59, bracket 3, the MA must not give a consent unless the MA is satisfied that the subject person is a fit and proper person to be such a director. Necessary information and documents have to be submitted in order to obtain the consent from the MA. Clause 60. It empowers the MA to attach conditions to the consent. The MA may attach conditions or amend the conditions. The licensee needs to provide written submissions within 7 days if he or she wishes to do so. Clause 61 empowers the MA to withdraw the consent. Before making the decision to withdraw the consent, the MA needs to write to the applicant for the applicant to provide a written representation to the MA within 7 days after receiving the notice. Clause 62 requires the licensee to notify the MA of any change or director of the licensee. Chris will speak on the policy considerations behind these subdivisions. Thank you. For the operation of a company, it is subject to the governance or management of a company. It plays a very important role, as the board of directors have a bearing on the business practice of a company. The appointment of directors need to be approved by the MA in advance. Dr. Tan Yueheng. Thank you, Chairman. Clause 58, I'd like to ask about directors. If a director is a chief executive, then that person may act in his or her capacity as a director. Then, does that person still need to apply to the MA to become a director? Please refer to clause 58 brackets 3. If one has already acted in accordance with clause 58, clause 54, that is about the appointment of chief executive or alternate chief executive, then one doesn't have to apply to the MA to be a director of licensee in accordance with clause 58. Subdivision 6, about the appointment of managers and employees. Clause 63 requires the licensee to notify the monetary authority of any change of manager of licensee. Any change needs to be reported to the MA within 14 days. Apart from the appointment of managers, or when the manager ceases to become the manager of a licensee, that is in accordance with Clause 63, Bracket 1, and in accordance with Clause 63, Bracket 3, Bracket B, apart from the specified affairs stated in notice under subsection 2b, the person is appointed as a manager of the licensee for any specified affairs in addition to or in place of any existing affairs. Clause 64 provides that a person must not become an employee of licensee without the MA's consent in certain circumstances. In special circumstances, a person must not become an employee of licensee if the person is bankrupt or has entered into a composition or scheme of arrangement with the person's creditors, or has entered into a voluntary arrangement as defined by Section 2 of the Bankruptcy Ordinance with the person's creditors, or has been convicted in any place of an offense involving fraud or dishonesty, then one will have to seek consent from the MA. Clause 65 provides that a person must cease to act as an employee of a licensee without the MA's consent in certain circumstances. The considerations are similar to those under Clause 64. Say one is bankrupt, or one has entered into arrangement with the person's creditors, or one has been convicted in any place of an offense involving fraud or dishonesty. Let's pause here, Ms. Carmen Khan. Thank you. For subdivision 6, only Clause 63 is applicable to authorized institutions. Regarding other provisions under subdivision 6, they aren't applicable to banks. Say when bank wants to operate stablecoins business, Clause 63 is applicable. Is my understanding correct? Why is it so? What managers are the managers in this case? There are managers managing different types of risks, so does one need to report to all managers? It's not clear as to which type of managers need to be reported to. We are only talking about fit and proper person. Just now Mr. Robert Lee also asked under what circumstances when one would be considered a fit and proper person. Directors, managers, are there any detailed guidelines as to appointment? Will you issue policy handbooks? Ms. Carmen Khan's understanding is correct. Clause 63 is only applicable to licensees that are authorized institutions. In the context of an authorized institution, a manager has to do with the specified affairs of stablecoin businesses, and this is set out clearly in Schedule 1 to the bill. Thank you. Whether we will issue regulatory guidelines to help the industry better understand the appointment of chief executive and managers, we will do so. We'll provide more guidelines so that the public will better understand the factors taken into consideration in appointing someone as a fit and proper person. We'll provide more details. Thank you.
Dr. Tan Yuan. Well, on Clause 64, So for an employee to become a certain persons to be employee of licensee, it's very strict. Well, I understand that a person cannot become an employee if he becomes bankrupt. But for B, it says if that person has entered into a composition or scheme of arrangement with the person's creditors. That actually is not something too detrimental. So why do you have to include B as well? Thank you. We agree. So in clause 64, bracket 1, bracket B, C, these are actually quite neutral conditions. So the MA may actually approve. Well, it's up to each case. It is not a set objection. So we still need to first get the consent of the MA before that person can become an employee of the licensee. All right, if there are no other questions, let's move on to subdivision 7 on a licensee appointing a stablecoin manager. We emphasize that this only applies to licensees of recognized institutions or of authorized institutions. So a licensee must appoint a person as a stablecoin manager of the licensee for the purposes of this ordinance. If a bank has set up a department to work on stablecoin and development and industry, then this person will then there would need to be a person to act as a manager. And so we can also see that in clause 67 for consent for appointing stablecoin manager, that as with the appointment of the chief executive, the monetary authority, when giving consent, must believe that the stablecoin manager must be a person who is ordinarily resident in Hong Kong and is a fit and proper person to be the manager. Clause 68 on the conditions for consent to be appointed as stablecoin manager. Additional conditions can be imposed. The MA can decide whether there is a need to attach or amend a condition and give a written notice to the subject person, and the person can, within 7 days after the day on which the notice is given, make written representations to the MA. Clause 69 on the withdrawal of consent by the monetary authority. The monetary authority, before issuing the withdrawal, must first give a written notice to the subject person on the intention to withdraw the consent, and the subject person may also, within 7 days after the day on which the notice is given, make representations to the MA. So under clause 70, if a licensee becomes aware that a person has ceased to be the stablecoin manager, then the licensee must within 14 days give a written notice of the fact to the monetary authority. Mr. Robert Lee, I would like to go back to C3324 on clause 67 on consent for appointing stablecoin manager, in which the subject person must be an individual who is ordinarily resident in Hong Kong and is a fit and proper person to be such a stablecoin manager. I want to understand that under the current bill, how are we going to view and consider persons who do not comply with these conditions, that they are not a ordinarily resident in Hong Kong? would you consider other conditions for those who do not comply with these two requirements? Or I see that these two requirements are the same for chief executive as well, but then I want to see why you also consider the same for stablecoin manager. All right, for non-residents of Hong Kong. Chris. Thank you, Chairman. Thank you, Mr. Lee, for your question. As you said, there are also similar restrictions on the chief executive, that the person must be an individual who is ordinarily resident in Hong Kong. Well, would a stablecoin manager need to meet these same requirements? Our legislative intent is that the stablecoin manager and chief executive are important and core persons of a company, and therefore these people would need to be liable and held accountable. Therefore, we do need a person who resides in Hong Kong. For other posts, then persons such as manager could actually be non-residents of Hong Kong. And those who work on the functions under Schedule 1 could be non-residents of Hong Kong. Well, I'm not sure whether you would consider multinational companies or cross-boundary persons. For a higher level management position, they may be engaged in practice or work in other places. For a company, there may be a few people managing parts of the business. It would not affect a manager engaging in work within Hong Kong, but there may be other managers who could provide support without such a resident restriction. Is there a flexibility? Or would you consider relaxing this requirement? Thank you for your question. Well, we consider 2 points. One, on how we can regulate under different jurisdictions, and second point, on the largest stablecoin industry on their feedback. Well, if you look at nearby jurisdictions such as Singapore, when Singapore issues a license to a company, then that company must be physical in Singapore. We considered the largest stablecoin issuers. For issuers who would like to acquire licenses, they would set up an office in the local jurisdiction to work with the local regulators. And of course, there would be a person liable in the company, which we refer to here as a stablecoin manager or a chief executive. As Chris said, there must be one person who could be held accountable in that local jurisdiction. Thank you. Mr. Chen Jianying, thank you. As this applies to authorized institutions, one person might be acting as managers for different businesses such as retail business, overseas businesses, company business. I've been wearing different hats at the same company before as well. Well, in a bank, then a person who is in charge of front line cannot act as the risk manager because that kind of work could not overlap. But then for here, could you actually state out whether the managers could take out different posts as well? Thank you. Of course, it must be approved by the monetary authority before we can appoint a stablecoin manager. The stablecoin manager can act as a manager. That manager can also wear different hats. Ms. Carmen can. I notice that subdivision 7 only applies to authorized institution, which is banks. Well, for C3322, clause 66, that when there is a vacancy in the office of a stablecoin manager, then the licensee must, as soon as practicable after the vacancy has arisen, apply for the MA's consent for a person to be appointed to fill the vacancy. And in C3324, it says that a violation would be an offense. Well, I understand that a replacement must be identified when a vacancy arises, but this stablecoin manager works in a bank. Well, would this manager also, would there also be an alternate stablecoin manager like the alternate chief executive? Otherwise, when a vacancy arises and you're not able to fill the position, then that would be in contravention of the bill. Oh yes, you are correct. The stablecoin manager here works in a bank, but we did not specify how or within what period of time the vacancy must be filled. So we just put down as soon as practicable. After the vacancy has risen, we want to allow some sort of flexibility because we know that a manager or the replacement might not be found immediately. So. And of course, the licensee would not be in contravention if a replacement is not filled. Well, as long as the vacancy is being filled as soon as practicable, then that would not be in contravention of the law. Well, so when you issue the license, well, you may not write it out in the law, but would actually arrange for an alternate stablecoin manager so that it would be same like the arrangement with the chief executive and the alternate chief executive. Well, we did not specify under stablecoin manager that there must be an alternate manager. Well, even if we have this written in black and white, even if there is an alternate, you still need to find a fit and proper person to act as the alternate. So the final approach we decided on was that as long as the vacancy is filled as soon as practicable, that would be enough. Thank you. Mr. Paul Tse. Chairman, can you please turn on the mic? Well, I've been reading through the division. A member of the general public might think that we are discussing very serious issues such as drug trafficking. I would like to highlight a couple of examples. For example, under subdivision 6, well, there is no definition of employee here. Well, we already see lots of titles such as chief executive, licensees, controllers, majority shareholder, controllers, etc. There are many different kinds of definitions. I may be too late in mentioning that, but if you're imposing all these restrictions and conditions, then you're indirectly managing everything. I don't understand why you're also trying to manage definition of an employee because you are actually putting a lot of restrictions. Do you really want to open up this business? I don't quite understand why you are imposing all these restrictions. A doctor does not need to acquire consent from a nurse before treating a patient. Why are we so scared?
Well, I'm not an expert in banks, but what are the concerns? What are the considerations? Why do we need to be so strict about this? Chris, we've drawn reference from the banking ordinance and the PSS VFO. The reason behind this is that the stablecoin issuer, as we understand, will be in control of the stablecoins held by users. Therefore, that will have to do with the handling of customer assets. If in the unfortunate event of, say, bankruptcy or any special financial arrangement or serious criminal offense, say offenses in relation to fraud or dishonesty, stablecoin issuers integrity may be called into question. That's exactly why we want to put in place a good mechanism to reduce the risks. Of course, the MA may consider the circumstances to grant consent. Well, is a cleaner an employee as well? Yes. So what if the cleaner is bankrupt and forgets to inform her employer? Is that against the law? Well, what if the employer of the financial secretary is bankrupt? If the financial secretary is not informed of the bankruptcy, does the financial secretary have to be imprisoned? Well, I'm not an expert in banks, but what are stablecoins? Why are we so strict about this? Well, the financial secretary, if the cleaner working for the financial secretary is bankrupt, and if the financial secretary is not informed of this situation, does the financial secretary need to be imprisoned?
同埋呢個係即係話 commit an offence 係嘛？
Well, is there no excuse, no defense, none whatsoever? If an employee doesn't inform the employer, then the employer needs to be imprisoned. Is that the case? The public coffers are in the red right now. If we need to seek or if we need to obtain consent from all employees, well, there's no wonder. It's no wonder that we are in the red. We need to protect the robustness of the financial system. That is right. But meanwhile, we want to develop business. Now, stablecoins are like ducks to me. Thank you, Chairman. I understand members' concerns. In accordance with Clause 65, brackets 1, under which there are 4 conditions. In that case, an employee of a licensee must cease to act as such an employee. Then that person will not be in breach of any criminal offense. That person then has to apply to the MA stating the fact that that person has any of these conditions. Then the MA will consider the situation. If the situation is material, then consent will not be given. If, on the contrary, the situation is not that material or is not that serious, the MA may still give the consent, and then the employee may still continue to be the licensee. So what is the rationale? Why do you have to sort of micromanage the situation? There's no definition for employees unless you give employees a definition that is employees in relation to transactions. Now you are just referring to employees in general. Even a part-time employee is an employee as well. Why do you still have to impose a criminal responsibility on this? We are a society with the rule of law. We aren't living in the past. Well, I understand I am repeating my question, but then the administration isn't answering my question. Well, you may propose a CSA, otherwise I find it absolutely unnecessary. All right. DS. We do want to develop the business or to develop the industry. Stablecoins are something novel in society. There are calls in society that we have to monitor the business strictly. For guidance notes issued by the MA or for a bill, we may need to provide more information. But we need to balance different calls in society. On the one hand, people want strict regulation. And on the other hand, we need to strike a balance between helping business survive and protecting investors. Well, this may sound all too good, but then you're stifling the development of the industry. Well, I cannot put up with it anymore. Excuse me, Chairman. Mr. Ronak Chan. Thank you, Chairman. Just now, Ms. Carmen Khan mentioned stablecoin manager. You said that time is needed for stablecoin managers for the position to be filled, so you didn't impose any time limit. Well, there are different kinds of managers in a bank. Say there are overseas business managers, there are risk managers, and so on. In other words, there is more than one manager. Say for the retail manager, you can have several managers, and there will also be several ACEs as well. When one of the ACE is out of Hong Kong, is on a business trip, then there are still other ACEs in Hong Kong. You just now mentioned one can be an ACE or a person can be different managers at the same time. So when one is out of office, the bank can ensure that the bank doesn't have to make another application immediately. And this is the actual situation in banks as I understand. Just now my question wasn't answered. For example, for risk managers, one person cannot be the risk manager and the stablecoin manager at the same time. One cannot wear two hats, so to speak. Say for IT manager, can Can a person be an IT manager and a stablecoin manager at the same time? Will you set out the details in guidance notes in the future? Just now, Mr. Porter asked why we need to have strict regulations. Well, you may see this as a banknote, but it is not in the form of a physical banknote. It exists in another form. That's exactly why we need to regulate these activities. For stablecoin issuers, it seems that you are micromanaging stablecoin managers, whereas the regulation over bank managers isn't as strict. Well, you may want to level with the public. In the supervisory guidelines, we may provide more details. We agree with member that we need to avoid conflicts of interest. A person cannot be a risk manager and a stablecoin manager at the same time. We'll set out these details in the guidelines. Thank you. Next member, Ms. Carmen Khan. Thank you. Well, Mr. Ronald Chen's question isn't answered. My question is similar to Mr. Ronald Chen's. In C3315, Subdivision 6 Managers and Employees, Clause 63 is applicable to banks. Only managers are regulated. For employees, we start with Clause 64 and 65. They are applicable to stablecoin issuers or licensees that are not in the banking sector. So when a bank engages in stablecoin business, only managers are regulated, employees aren't regulated. Clauses 64 and 65 aren't applicable. For the three sandbox operators, when they go to apply for stablecoin licenses, then they will be subject to regulation in accordance with clauses 64 and 65. Say in the case of bankruptcy or conviction in relation to offenses about dishonesty or fraud, all employees, including cleaners, will have to fulfill all the requirements, or consent will have to be given, failing which it's illegal. Well, you need to clarify in a stablecoin business, whatever ranks, whatever positions, you need to obtain consent. Is it that person in question breaking the law, or is licensee breaking the law instead? Thank you, member, for your questions. From what I understand, when bank engages in stablecoin business, managers are regulated. For non-banks, all employees need to be regulated. Banks are regulated by the MA. Therefore, for internal control, there is certain protection. In other industries, I'm not saying they are good or bad, but as general observation, for organizations which are not licensed organizations, the situation may be different. So I'd like to take a risk-based perspective. For non-banks, when they want to apply for a license, is the risk different? If so, then we need to handle the situation in a different manner. For non-authorized institutions, we need to tread more cautiously. We don't know what kind of employees they want to engage. That's why we need to rein in the control. Say for bankruptcy, we want to understand, we want to know whether there are special issues giving rise to concerns. Just how Mr. Ronald Chen said, it is similar to having banknotes. Say if 5 employees out of 10 employees working in a fiat reference stablecoins are bankrupt, then this may give rise to concerns among members of the public.
So, Chairman, who is actually contravening it? You're talking about the person who is bankrupt, not the licensee. Ernest. If the employee becomes bankrupt, then the employee, the individual, will be contravening the law, not the licensee. Or hope that you could make this clear. Well, because this is different. Stablecoin is a new industry. We do need to allow some flexibility. Mr. Chen Chen-ying, I would like to ask whether the administration will consider defining the term employee. That this is an employee whose work is related to stablecoin industry, then you would not actually be including an employee who works at the pantry or a cleaner. Those are all employees. We can actually state clearly that this is an employee whose work is related to stablecoin, then that would be more reasonable. Ernest. Now we can bring this back and consider this later. Thank you. Any other questions on subdivision 7? If not, then we would move on to subdivision 8. So subdivision 8 will be on employment of officer in case of winding up. So that clause 71 and 72 will fall under that. So for a person whose license has been wound up or otherwise dissolved or has revoked, and that person as an officer of the first licensee, if that person becomes an employee of a licensee in contravention of subsection bracket 1, then that person ceases to act as an employee. And for clause 72, consent is required for an officer to continue to act as an employee of another licensee. And clause 73 will be under subdivision 9, which is sale and disposal of business and reconstruction of capital. Except with the MA's prior written approval, a licensee must not make an arrangement or enter into an agreement for the sale or disposal of the whole or any part of its business. A licensee that makes or enters into an arrangement or agreement must, as soon as practicable after doing so, notify the MA of the arrangement or agreement by written notice, signed by the director of the licensee. Clause 74 states that a licensee that makes a reconstruction of its capital must, as soon as practicable after doing so, notify the MA of the reconstruction by written notice, signed by a director of the licensee, and the monetary authority may, by written notice, require the licensee to provide further information. Ms. Carmen Ken. Mr. Win Kong. Chairman. I'd like to go back to clause 66 on C3323 that if a vacancy arises in the office, then the licensee must, as soon as practicable after the vacancy has arisen. So when would the vacancy arise on the day that the person leaves the position, or how do you define it? Oh, this question has already been answered, but Chris, can you tell us more about it? Well, yes, when the person ceases to be an employee in the office. All right, thank you. Let us move to subdivision 10, miscellaneous. So this would apply to license holders. Clause 75 provides the MA to seek additional information when needed. Since there are no other questions, I'll move on to Division 4 on control over licensee. This includes Clause 76 to 97. So this would set out the powers of the MA over the management of licensee, and we have also drawn reference from the Payment Systems Ordinance. So this specifies that the division does not apply in relation to a licensee that is an authorized institution. Clause 77 states that the monetary authority can exercise in relation to a licensee one or more of the powers under Section 78, 79, and 80 that appear to the monetary authority if it meets the conditions listed under 77A, B, and C. A states that if the licensee informs the monetary authority that the licensee is likely to become unable to meet its obligations, is insolvent, about to suspend payment, or about to suspend any of its business activities under its license. And B, the licensee is really unable to meet its obligations, or that the monetary authority is of the opinion that the licensee is likely to become unable to meet obligations. Ms. Carmen Ken, Chairman, I may be slow in reading this through. I'd like to go back to Clause 73, C3340, Clause 73, that the monetary authority must give written approval on the sale and disposal of business. I agree with that because the licensee must require approval before entering into business. So, of course, the sale and disposal of business would also require approval. Would that also include the transfer of sales as well? I understand that when there is a change in controller, then that would acquire approval. But then when we're talking about sale and disposal, we're talking about transfer of sales, of shares as well. Are shares included? Or maybe it is already approved by the minority shareholders or the majority shareholders. When the sale of shares do not affect the minority and majority shareholders or indirect controllers, then that would not require approval. But then for a sale and disposal of business or shares, that would require approval. Can you clarify that point? Thank you, Chairman. Thank you, Ms. Khan. Your understanding is correct. Clause 73 mainly focuses on the sale and disposal of business and not shares. Thank you. Mr. Adrian Ho. Thank you. I'd like to move on to Clause 77, 78, and 79 on the powers of monetary authority over management of licensee. Well, under the conditions listed out under Clause 77, the monetary authority can exercise power under certain circumstances. When I look at Schedule 4, if these conditions are not met, then there will be a revocation of license. Well, last time when we were discussing 32, 33 on the temporary suspension of license, these are actually reasons on the revocation of license. So can you explain further? So what circumstance would 32, 33, 77, 78, and 79 fall under? Thank you, Chairman. Thank you, Mr. Ho, for your question. In the last meeting, we spent a lot of time discussing this. This empowers the MA to exercise certain powers. For example, on 32, 33, 78, 79, that would depend on the circumstances. The monetary authority believe that it is too radical to just revoke a license. Therefore, before doing that, it must allow the licensee holder to take remedial actions. For example, there might be a temporary suspension of license that within 14 days, actions may be taken. But if it fails, then there might be a temporary suspension of license. When the monetary authority believes it appropriate, then it could actually introduce consultants to assist the licensee in the improvement of its businesses, and so the suspension of license or other drastic actions would not be taken. Thank you. Mr. Oin Kong, Clause 77 listed out conditions when the MA could intervene. I would like to try understand 77C. Roman numeral 5. That the license is about to suspend any the license is carrying on its business in a manner detrimental to the interests of the holders or potential holders of any specified stablecoins connected with the license. What do you mean by potential holders? That might refer to a lot of people. Why do you have to put down potential holders? Because that would include everyone. Can you give me specific examples on what you mean by then? 5 and 6. 6 is on carrying on its business in a manner detrimental to the interests of its creditors. So can you give me examples on what cases would fit in 5 and which would fit into 6? Thank you for your question. Well, for 5, a licensee is carrying on business detrimental to the interests of holders or potential holders. When we look at stablecoin, a very important feature of stablecoin must be fully backed by fiat. The issuer, when issuing a token, must be backed by the same value fiat reference. Well, so when the licensee transfer this stablecoin to another holder, and this is a potential holder, then when action is taken in which it might be detrimental to the interests of the holder or potential holder, then this would be one example of Roman numeral 5. Well, it's very difficult to come up with just one example. I think this bill is much more complicated than other similar bills in other jurisdictions. I understand you want to protect the interests of consumers and licensees or members of the general public, but then you cannot go too far. Well, I understand your point, but then why do you have to also include potential holders? Because anything you do could be detrimental to the interests of the rest of the world. Because if you put this down in the bill, even if you narrow down the guidelines, the clause will actually affect those who want to engage in such business? And what is the difference between 5 and 6? Can you give me other concrete examples on 6?
係，多謝主席。
Thank you, Chairman. Thank you, Member, for your question. If licensee has too much debt, this will be detrimental to the interests of holders. So, what is your definition of too much debt? Well, if one takes up a lot of debt to operate the business, this will be considered to be having too much debt. Well, this is a bills committee. Do you have any definition, any figures? Well, I'm afraid we have to adopt a case-by-case approach. It's difficult to have an across-the-board definition or specific threshold. We cannot generalize the requirement. Ms. Carmen Khan. Thank you, Chairman. Let's take a look at C3347. This division is not applicable to authorized institutions. So when it comes to the requirements imposed on licensees, say in clauses 77, 78, 79, and 80, we may impose or we may give the MA different powers. Did you draw reference from the banking ordinance as well? Just like we want to regulate a bank, therefore, this division is not applicable to banks. Is that the case? We have indeed drawn reference from other ordinances. The first one is the PSS VFO, 8ZF, AZH, and 8HG. Under the banking ordinance, section 5253A, there are the relevant contents. So in the Stablecoins bill, this division is not applicable to authorized institutions. Well, in the interest of time, I'd like the administration and the MA to think after the meeting. You have drawn reference from Cap 5A4. What business is similar to stablecoins in relation to risks? You use the principle of same activity, same risk, and same regulation. We need to strike a balance between development and regulation. That's because the focus is on the word same. You think there are risks in a certain area, but the industry may think otherwise. If we can reach a consensus, then there will be no argument. Oftentimes, we talk about drawing reference from the banking ordinance and from the PSS VFO. We need to think, or the administration needs to provide a reply. We need to be on the same page. We need to be on the same page. Well, probably the administration can tell us why the regulation of stablecoins is similar to that of banks. Well, I'd like to respond to Ms. Carmen Khan in brief. This is a relevant question. The reason why we drew reference from the banking ordinance is that these businesses such as the stablecoins are financial services as well. Of course, we aren't copying and pasting exactly the same content. Regarding drawing reference from the PSS and VFO, say Octopus card. You can tap your Octopus card when you store value in the card. Octopus card per se is a little bit similar to stablecoins. It is a tool for you to settle payment. The difference is that stablecoins aren't limited to domestic payments. They are available on blockchain for you to settle different transactions. We need to consider the risks, regulation, and activities. But are they the same? No, not really. Otherwise, we wouldn't need yet another piece of legislation. They are similar, however. We have drawn reference from the banking ordinance as well as the PSS and VFO, but we make adjustments from time to time. Thank you. I'd like the administration to dive into the situation. Say there's a wallet and the public's money is stored in the wallet. The payment tool per se isn't banknotes that have been issued. It is similar to a note issuing bank. Probably the administration can prepare a paper. Then we'll be in a better position to know what kind of risks we are facing. Only then will we be able to tell whether this is the principle of same activity, same risk, and same regulation. This is well worth the time. We are pioneering stablecoins, so we need to explore this area. We encourage innovation. We aren't working on a simple Octopus card system. That's exactly why I provided papers before the meeting commenced. We need to know whether our bill is competitive, whether we can attract potential stablecoin issuers to come to Hong Kong. Thank you, Chairman. I agree. When we drafted this piece of legislation, we drew reference from Japan, Singapore, EU, as well as the law drafting in the United States. We are more comprehensive in some areas. The U.S. focuses on payment. However, there are no restrictions imposed by us. This is my brief response, but then we can provide a more detailed written response after the meeting. Thank you, Mr. Adrian Ho. I find the response from the administration reasonable. We need to allow flexibility. Say the Schedule 42 bill, when you revoke the license, we have clauses 77, 78, 79, and 80 as well. But are there any internal guidelines? Under what circumstances are clauses 32, 33, 78, 79, and 80 fulfilled or met? When situations in Schedule 4 to the bill arise, will that give rise to any problems about fairness? When there is an advisor, will there be a time limit or an exit mechanism like that mentioned in clauses 32 and 33? Thank you, Chairman. Thank you, Mr. Adrian Ho. We'll consider your suggestion and look into the situation regarding any time limit and exit mechanism. In a moment, we'll talk about it in greater detail. We can set time limits in written notices. There are also provisions about the mechanism. Just now we were on clause 78. Let's continue. Clause 78 empowers the MA to require a licensee to take an immediate action in relation to the licensee's affairs, business, or property. If one doesn't act according to the notice, then one commits an offense. Clause 79 empowers the MA to direct the licensee to seek advice from an advisor appointed by the MA. Brackets 1, brackets B. By written notice to the licensee, the MA may direct the licensee to seek advice from the advisor. Let's pause. Mr. Rock Chan, I'd like to ask about Clause 78, bracket 3. The nature is similar to the discussion of Clause 77. Under Clause 78, bracket 3, the penalties in relation to summary conviction is a fine at level 6 and to imprisonment for 6 months. However, for conviction on indictment, a fine of $2 million and imprisonment term of 5 years may be imposed. Did you draw reference from different risks and different business models, hence the difference between 6 months and 5 years? Chris? Thank you. Division 4 is not applicable to authorized institutions because under the banking ordinance there are appropriate provisions available. So we'll see if we need to amend the penalties the penalties on summary conviction. We'll need to take into account the differences in the scope of the banking ordinance and that of this ordinance. We'll go back and study this point. We'll have a follow-up. I'm not advocating a stiffer penalty like other colleagues or members. If there are different activities, risks after study, it may be possible, but you need to tell us. Mr. Oren Kong. Thank you, Chairman. I'd like to ask about Clause 79. It is said that the MA may appoint a person to be an advisor of a licensee. I'd like to ask, does this bill state very clearly the advisor, licensee, and the MA, what are their legal relationships? Thank you. Can I seek clarifications? Among whom? Whose agent? What if the advisor is not correct? When there's negligence on the part of the advisor, whom can we pursue? Thank you, Chairman. Thank you, Member, for your question. Regarding the legal relationships between the issuer and advisor, there is a legal relationship. The advisor is appointed by the MA. In the written notice, there will be detailed explanations, say business, property, management, and so on. Well, in the ordinance, probably I missed it. In the interpretation and in Clause 79, it seems there is no mention of the legal relationship, say agent, employee, the cost is borne by whom, who is to be held liable. There is no such information. You simply set out appointed by the MA. So to me, by the looks of it, it seems it is the MA that is the one appointing that person, the advisor. Well, say in clause 90 we'll come to this. Well, I don't mind, but can you let me know which provision? Can you tell me which clause? Clause 93. In clause 93, we'll talk about the revocation of appointment, clause 94, resignation of advisor, and so on. Thank you.
提到嗰個
I would like to supplement on the payment. Actually, under clause 97, you'll be able to find it, and then you'll be able to see the remuneration and expenses of advisor or statutory manager under that clause. All right, I would ask my question when we reach that clause. Thank you. Now, moving on to clause 80. Clause 80. Power to direct that licensee's affairs be managed by a statutory manager. The monetary authority can, by written notice to the licensee, direct that while the direction is in force, the affairs, business, or property of the licensee to which the direction relates are to be managed by the statutory manager. And in accordance with 3(b), the monetary authority must specify in the terms of the direction the objectives with which the statutory manager must comply. The monetary authority, after appointing such a person to be a statutory manager, must publish a notice of the fact that a direction has been given in the Gazette and in any other way that appears to the MA to be expedient for notifying the public of that fact. Clause 81. On supplementary provisions, the monetary authority can appoint 2 or more persons to be an advisor or statutory manager of the licensee. When there is more than one statutory manager under Section 3(a), the monetary authority must by written notice specify which of the duties and powers imposed or conferred under this ordinance on a statutory manager may be discharged or exercised. Bracket 5. The monetary authority must publish a notice of the fact that an appointment notice has been given in the Gazette or in any other way for notifying the public of the fact. Clause 82. Clause 82 on revocation of direction. The monetary authority may, after consulting the financial secretary by written notice, revoke a direction. Thank you. Ms. Doreen Kong. Thank you, Chairman. I'd like to ask the administration about clause 78, 79, and 80, that power has been given to the monetary authority to intervene. Well, but from the perspective of the licensee, could clauses 78, 79, 80 be checked, because they may think that there is no need for intervention. I know that the court of first instance can also make direction, but I'm not sure whether this section is applicable to the licensee, because the monetary authority may be in the wrong. Can the licensee under clauses 78, 79 on make an appeal? Well, in subsection 7, there would be a stablecoin tribunal. Clause 140, and a person who is aggrieved by a specified decision may refer the decision to the tribunal. And this include any decisions made. So clauses 78, 79, and 80 would be under the ambit of the tribunal. Thank you. So there is no appeal mechanism. It would go directly to the tribunal. Thank you. Ms. Carmen Kent. Thank you, Chairman. Mr. Adrian Ho also asked a similar question. It appears that based on the licensees' affairs and after seeking and consulting the financial secretary, a direction can be revoked. I'm sure that you would clarify some of the concerns raised by Doreen Kong and I. When I'm reading through the bill, it seems that under the directions, you would list out the conditions, the relationship, the objectives. But then for the statutory manager, it seems that it's different from bankruptcy. On page 3352, under 80, bracket 5, that when there is an order for the winding up of the licensee made, then the MA must not give a direction to a licensee. So this is not exactly receivership. So what kind of procedure are you referring to? We want to understand whether all the licensees must be residing in Hong Kong. Some licensees may be in another overseas jurisdiction, but then they may be working actively in the market. Or do all the licenses be set up in Hong Kong? Well, let's say they want to issue something in Hong Kong dollars, but this all go under the jurisdiction in Hong Kong. When we are referring to the different powers empowered to the monetary authority, you drew reference from PSS VFO. Are we facing the same risk? Does a PSS VFO require a reserved asset? So for those under Octopus, would that be 100% fiat reference stablecoins as mentioned under this bill? We want to understand whether the risks are the same. I know I'm asking similar questions, but I hope that we can help the administration clarify some of the concerns in subdivision 2. Ernest or Chris? Chris, thank you, Chairman. Thank you for your question. Clause 80, bracket 5, your understanding is correct. When a company is not winding up yet, and only when an order for the winding up of the licensee has been made can the monetary authority give a direction to a licensee. Your understanding is correct. For a licensee, does it need to be set up in Hong Kong? We would see in Schedule 2 that requirements are made that a licensee must be a locally incorporated company. Other than authorized institutions that are incorporated outside Hong Kong, others must also be locally incorporated. Yes, we have due reference from PSSVFO to design clauses 78 to 80. We decided to draw reference from this ordinance because under PSSVFO, a stored value facility licensee must ensure float protection, and that is similar to a safekeeping of custody under this bill. But do you have the same reserved asset requirement for both? are you asking for the same reserved asset for store value facility and for stablecoin? Well, can you actually compare it apple to apple? Or how can we compare it with other jurisdictions? Ernest, thank you, Chairman. Thank you, Ms. Khan. Yes. There should be float protection as mentioned by Chris. The fiat reserve management requirement should be compared with SVF and also with similar institutions in other jurisdictions. We have considered how it is done in the US and Singapore, what is considered a fiat referenced reference. They would consider high liquidity assets. Those could be considered as part of the fiat reference. Or how about for reserve asset? Well, those are not exactly same activities, therefore requirements could not be the same, but the float protection and the banking idea is similar. Well, I think we're just looping around the same issue. We have a due reference from overseas jurisdictions, but in terms of management, licenses, we have also drew reference from the banking ordinance, and so there is a bit of confusion here. I would suggest you provide a comparison in writing for our reference later. All right, let's move on to clause 83 on references to affairs, business, or property of license and objective of statute manager. So we would look into affairs, business, or property, or any combination of them of the licensees to be construed as the affairs, business, or property as specified in the terms of direction, and also the primary objective as specified in terms of direction. Clause 84 on a direction given under Section 80 taking effect in respect of a licensee and A and B, that an appointment of a person as a chief executive or a director of the licensee that was in force immediately before the direction takes effect is to be regarded as revoked. And during the validity of the direction, the person must not act as a chief executive or a director unless it is expressly stated that the appointment is not to be regarded as revoked. Ms. Doreen Kong, I would like to ask about 84 bracket 1 bracket B. Here it said, accordingly, the person must not act as a chief executive or a director while the direction is in force. A is very clear. You would revoke it. But B means that does it mean that this person cannot act as a licensee in the future, or that person must not act as a chief executive? Because A, you talked of a person of the licensee, but you did not put of the licensee in B. Can you clarify it? Chris. Thank you, Chairman. Thank you. Well, B is actually supplement to A, because for A, an appointment of a person as a chief executive would be regarded as revoked on a direction given under Section 80 taking effect. As this is automatically revoked, then that person could not act under the same post. That person cannot act as a chief executive. So this is actually supplement to A. Chairman, I think that for the English version is that the person must not act as a chief executive or director, but you didn't make clear that it is the person as chief executive or director of a licensee. Because if I'm just a layman, I would think that you will not allow that person to be a licensee ever again. And secondly, if that person cannot act as a chief executive, can that person act as a senior managerial staff?
Can one still be a high-ranking official within a company even if he or she is not going to be the director? No, there's no prohibition in this regard. We'll liaise with the DOJ to review the drafting to see if we can improve the readability of the provision. We'll see if we will propose a CSA. Thank you. Let's move on to Clause 85. Clause 85 provides for the effect of the direction on certain meetings of the licensee and resolution passed at such meetings. No general meeting of the members of the licensee or meeting of the directors of the licensee may be held except with the consent and in the presence of a statutory manager of the licensee. And B, if any such meeting is held with the consent in the presence of a statutory manager of the licensee, no resolution may be passed at the meeting except with the consent of the statutory manager. If a resolution is passed in contravention of subsection brackets 1b, the purported resolution and anything done in reliance on the purported resolution is invalid because of the contravention. Clause 86 deals with the power of a statutory manager. Brackets 1. Subject to the primary objective with which the statutory manager of a licensee must comply, the statutory manager may do anything necessary for the management of the licensee's affairs, business, or property that is in relation to brackets A. And in brackets B, without limiting paragraph A, may exercise one or more of the powers specified in Schedule 5, which we'll come to in a moment. A statutory manager of a licensee may call a meeting of the members, directors, or creditors of the licensee Well, should I proceed to introduce Schedule 5? Yes, please go ahead. Schedule 5 is about the powers of statutory manager of licensee. 1. Power to take possession of, collect, and get in the property of the licensee, and for that purpose to take proceedings that the statutory manager considers expedient. 2. Power to purchase property for the licensee. 3. Power to sell or otherwise dispose of the business or property of the licensee by public auction or private contract. 4. Power to raise or borrow money and, for that purpose, to grant security over the business or property of the licensee. 5. Power to appoint a solicitor or an accountant or other professionally qualified person to act for the licensee. 6. Power to exercise any voting rights in respect of any shares owned by the licensee. 7. Power to bring or defend any action or other legal proceedings in the name of or on behalf of the licensee. 8. Power to give guarantees in the name of or on behalf of the licensee. 9. Power to refer to arbitration any question affecting the licensee. 10. Power to take out and maintain any insurance in respect of the business and property of the licensee. 11. Power to use the seal, if any, of the licensee. 12. Power to do any act for executing in the name of or on behalf of the licensee any deed, receipt, or other document, including power to enter into, carry out, assign, or accept the assignment of, vary, or rescind any contract, agreement, or other obligation. 13. Power to draw, accept, make and endorse any bill of exchange or promissory note in the name of or on behalf of the licensee. 14. Power to appoint an agent to do any business that the statutory manager is unable to do personally or that can more conveniently be done by an agent, and power to comply, direct, and dismiss employees. 15. Power to do any act that the statutory manager considers necessary for the realization of any property of the licensee, including power to carry out works. 16. Power to make payment that is necessary or incidental to the performance of the statutory manager's function. 17. Power to carry on any business of the licensee. 18. Power to grant or accept a surrender of a lease or tenancy of any property of the licensee and to take lease or tenancy of any property required or convenient for the business of licensee. 19. Power to make any arrangement or compromise on behalf of the licensee. 20. Power to call up any uncalled capital of the licensee. 21. Power to rank and claim in the bankruptcy, insolvency, sequestration, or liquidation of a person indebted to the licensee and to receive dividends and to accede to trust deeds for the creditors of any such person. 22. Power to change the location of any business office of the licensee. 23. Power to do any other act that is A. incidental to the exercise of the power set out in this schedule, or B. consequential on or conducive to or expedient for compliance with the primary objective with which the statutory manager must comply. Alright, let's pause and let members ask questions. Just now we've heard from the administration the relevant powers under Schedule 5. It is subject to the Clause 80, Bracket 3. That is the one or more primary objective with which the statutory manager must comply. And the direction is specified by the MA. If the CE, ACE cannot be the director, and the general meeting has to be convened with the consent of the statutory manager, but then the company hasn't yet entered into bankruptcy or winding up procedures yet. Meaning there is no creditor at that moment. No creditor calling for liquidation for the moment. Well, member is largely correct. When there are special circumstances, only then will the MA appoint a statutory manager, say when a company is insolvent because of ill management. Then, a statutory manager may be appointed to take possession of and manage the business and property of the company. And in Schedule 5, powers of the statutory managers of the licensee are set out to better manage the business or to take remedial actions. That is the policy intent behind this section. It's not just a debt, it may be due to management issues. It may have to do with internal control, risk control. It may not necessarily have to do with debt issues. Should you settle clearly without compromising the interests or rights of the creditors or the third parties, and the third party are still at liberty to wind up the business? Do you need to settle clearly this? Yes, Ms. Carmen Kang's question is correct. even with the appointment of the statutory manager, creditors can still apply for winding up of a company or a business. And there is no need to set out, there is no restriction either, is that correct? Well, we can double check, but there is no mention of this. The administration and the DOJ can consider this. Thank you, Ms. Doreen Kong. Thank you, Chairman. The statutory manager has a lot of powers. I've read Schedule 5. Of course, it is different from a financial organization. We are talking about applying for a license to be a stablecoin issuer, but then the powers really surprise me. The statutory manager is actually above the board of directors or the shareholders. If the statutory manager has such powers, is there any mechanism to protect the licensee in case of any potential conflicts of interest? Well, I take the perspective of not just the public, but also the licensee. Regarding Clause 86 in Schedule 5, well, I understand the statutory manager is appointed by the MA, but then does the statutory manager take the perspective of the licensee or the public or the creditors? Why is this question very important? That is because it has a bearing on the future liability of the statutory manager. He or she may not necessarily do all the things correctly, so we need to know the perspective or the stance of the statutory manager. What kind of fiduciary duty does the statutory manager have? Or is the statutory manager free from any liabilities whatsoever? Well, I think the statutory manager has a lot of responsibilities. Can professional indemnity insurance be taken out to protect the business? Right. The representative or the representation of the statutory manager and professional insurance of the statutory manager. Well, before the appointment of the statutory manager, of course, we take into account any potential conflict of interest. The list is not exhaustive, but then it is actually one of the factors we take into account. We also consider the professional know-how of the statutory manager and whether he or she has the capacity to do so in relation to any ordinance about the contravention of any fiduciary duties. What kind of consequences does the statutory manager have? Clause 86, subclause 6. The prevention of bribery ordinance is applicable to the statutory manager as well. We do want to prevent any possible bribery, to prevent any statutory manager from not acting on the MA. Regarding whether the statutory manager has the position of the public or of the MA, well, it depends on the direction of the MA. Probably the direction is that the MA thinks that the statutory manager may have to maintain the number of indemnity. And in this case, of course, the stablecoin holders are protected, and the stablecoin licensees are also protected as a result. That is to ensure smooth operation. So it's difficult to generalize the position of the statutory manager. The statutory manager does serve every party. Well, I have a follow-up. Thank you for referring me to bracket 6. The statutory manager is the agent of the licensee. In other words, when the statutory manager makes any mistake, in theory, the licensee can claim the statutory manager for any mistake made. So, is there any requirement for the licensee to take out sufficient professional indemnity insurance? The statutory manager has a lot of powers under Schedule 5 to the bill. Is there any requirement in relation to insurance or any amount thereof?
局方代表係 Chris 係。
係，多謝主席，多謝。
Chris, thank you, Chairman. Thank you for your question. Well, when a statutory manager is appointed, then of course they can make their own decision on any purchase of insurance on indemnity. I think this is up to the licensee. We do not make this a mandatory. Ms. Khan. Well, I understand. Well, you're trying to protect the interests of the public. If this statutory manager can do whatever he wants, then how would the licensee or the interests of the public be protected? This is very important. Well, this is not a financial institution. Well, when this manager is to be liable, would that manager be able to compensate the public or the licensee? Well, even lawyers will need to purchase insurance. Ms. Khan? Well, 3366, also on subclause 6, which Ms. Kong asked about. Would the original legislative intent be also applying Section 9 of the Prevention of Bribery Ordinance here, that any other person involved could not be bribed and that no bribery should be involved between that person and the statutory manager? And so the statutory manager is to be regarded as acting as an agent of the licensee. I think this is for the purpose of this content only. Otherwise, it will fall into our understanding that it applies to all circumstances, that the agent of the licensee would see this applicable. I don't think that's the case. It is only because you want to invoke the Prevention of Bribery Ordinance, then only would the statutory manager be regarded as acting as an agent of the licensee. So is that the original legislative intent for that? Generally speaking, if you refer to AT bracket 2, the statutory manager can be an entity or if I could refer you to AT1 bracket 2, can you explain to us? Because a statutory manager may be a body corporate, a partnership, or a person appointed. So who would that person be? A receiver? How can we understand this? Who are you referring to? These professional bodies should also have indemnity. I think you should give us some examples. Thank you. Chris. Thank you, Chairman. Thank you, Ms. Khan, for your question. You're correct. Under 81 bracket 2 on body, corporate, and partnership, it is professional bodies such as law firms or consultancy firms. These corporates could be a statutory manager. as to whether they're acting as an agent of the statutory manager, if I could refer you to clause 86, bracket 6, as long as the statutory manager complies with the powers conferred under this ordinance, then that manager would be regarded as acting as an agent of the licensee. So if the powers are not given under this clause, then acting outside of this ordinance would not be seen as an agent of the licensee. We would go back and see whether there is a need to move CSAs here. I find it difficult to understand. Please try to clarify it later. All right, I think we can now move on to clause 87. Clause 87 on offense in relation to powers of statutory manager, that a person who fails to comply with the requirement imposed under section 86 bracket 2 bracket B commits an offense and if there is no reasonable excuse, then that is an offense. Clause 88, delegation by statutory manager. But this must be with the written approval of the monetary authority, which is stated under bracket 1. Clause 89, to empower the court of first instance to approve certain resolutions in respect of a licensee approve or refuse to approve a resolution. And that must also comply with the requirements as set under bracket 1A to C. The application can be raised by the statutory manager of the licensee or not less than 100 members of the licensee or of members of the licensee holding not less than 10% of the issued shares in the licensee. Clause 90, to empower the court of first instance to make certain orders. Bracket 1. And when the court of first instance makes orders, then who could make an application? And this must be made by a statutory manager. When a statutory manager finds that a person is about to do an act or is about to do an act that may adversely affect or conflict with the discharge or exercise of the statutory manager's duties or powers in respect of the licensee, then an application may be made. The orders can restrain the persons from doing the act mentioned in the subsection, and under 2B, in order to declare that with effect on and after the date of the order, the act mentioned in that subsection is invalid. Clause 91. Oh, please stop here, Ms. Doreen Kong. Chairman, in Clause 89, it appears the court of first instance can approve certain resolutions. To approve or refuse to approve a resolution. Bracket B and C can be made by members of the licensee. One is not less than 100 members of the licensee, the other being members of the licensee holding not less than 10% of the shares. Why is the threshold so high? How do you protect small investors? Well, I don't want to waste time, but I would like to hear why you set the threshold at 10%. Thank you, Chairman. Thank you, Ms. Kong, for your question. The scenarios of A, B, and C would not occur at the same time. It would only happen one at a time, and mostly we would see scenario A. For B and C, we know that we've already defined what is meant by a controller. So that would refer to a shareholder. Statutory managers may need to make decisions that may be approved by the at shareholders meeting, but sometimes there may not be a majority, and the court of first instance may need to help approve certain resolutions. So for C, an application of members of the licensee holding not less than 10% of the issued shares in the licensee, I think this refers to a total of 10%. And that would be a sign of support, which could then allow them to raise this to the court of first instance. Well, yes, the question is, why is it set at 10%? So did you draw reference from another bill? Oh, yes, from the PSSVFO. Thank you. Okay, Clause 91. A person must not willfully obstruct, resist, or delay a statutory manager of a licensee in the lawful discharge of any of the statutory manager's duties in respect of the licensee, otherwise it would constitute an offense. Clause 92, to empower the monetary authority by written notice, vary the direction in respect of either A, B, or both. Under A, it refers to the affairs, business, or property of the licensee that is to be managed by a statutory manager of the licensee, and B, the primary objective with which a statutory manager of the licensee must comply. Clause 93. The monetary authority may at any time revoke the appointment of an advisor or a statutory manager. Clause 94. An advisor or a statutory manager of a licensee may resign from office by giving written notice to the monetary authority. Clause 95. On filling vacancy in office of advisor or statutory manager. When there is a vacancy, the monetary authority must, as soon as practicable after the vacancy arises, fill the vacancy. Clause 96, to empower the advisor or statutory manager with the approval of the monetary authority to engage a person to assist in the discharge or exercise of duties. And Clause 97, determine the remuneration or expenses to be paid by a licensee. Bracket 1 points out that the monetary authority may, after consulting the financial secretary, determine the remuneration or expenses to be paid by a licensee to the advisor or statutory manager of the licensee. The monetary authority may, after consulting the financial secretary, use the exchange fund to pay the whole or part of the remuneration or expenses. Hold on, please, Ms. Doreen Kong. Thank you, Chairman. Oh, sorry, I'm a bit slow. Can we go back to Clause 92 on a variation of direction? I see that when there is a vary of direction, then written notice may be given. But this direction must be given to the licensee and the statutory manager. But Clause 80 and 97 are actually related, because for Clause 80, the notice must be gazetted and that the public must also be notified. When under Clause 80, you need to publish a notice that a direction has been given in the Gazette and that the public must be notified. But then when you vary the direction, you didn't make the same or didn't set the same requirement, you still need to notify the public because nobody would know that a variation has been given.
All right, about variation of direction. Thank you, Chairman. Thank you, Member, for your question. Well, when the direction needs to be varied, the MA may have to give a new direction based on the statutory manager's disposal of assets. Directions may be given by the MA. And then, in accordance with Clause 80, Bracket 6, the MA must publish a notice of the fact that a direction has been given. Well, excuse me, there is no provision under Clause 92 that a notice must be given. I fail to see that. Well, what about Bracket 1? Thank you, Member. We'll discuss with the DOJ. If need be, we will amend the drafting of the provision. Thank you, Ms. Carmen Khan. Same question. I'm on the same clause. Clause 92, Bracket 4. This is moved from the PSS and VFO, is that correct? Anything done in reliance on a direction before a variation is made is not invalid only because of the variation. I'm not sure about the purpose of Bracket 4, and you need to clarify how the persons affected will know about this. Bracket 4 is to protect those who are not aware of the variation. So anything done in reliance on it before a variation is made will not be invalid. Chris? I can give you an example. In Schedule 5, there's a series of powers given to the statutory managers, say the purchase of assets. In the case of a variation of the direction, the contract will not become invalid. Well, so the third party is protected as well. You need to make sure about this. Is that correct? All right. Let's move on to Clause 98. It provides for matters relating to the winding up of licensee. The provisions of the Companies Winding Up and Miscellaneous Provisions Ordinance regarding a creditor's voluntary winding up do not apply to a licensee. Clause 99, the MA's power to modify or waive application of minimum criteria. The prerequisite is, as stated in Subclause 2, the MA must not grant a modification or a waiver in relation to a subject person unless it is satisfied that A, the subject person carries on a business of issuing specified stablecoins that is subject to adequate supervision of an authority or regulatory organization outside Hong Kong that, in the MA's opinion, performs in the jurisdiction of the authority or regulatory organization a function similar to the MA under this ordinance. B. The grant of the modification or a waiver does not pose any material risk to one, the holders or potential holders of any specified stablecoins issued by the subject person, or to the monetary or financial system of Hong Kong. The MA may grant a modification or a waiver under subsection 1 subject to any condition that the MA considers appropriate. Moving on to Part 3 of the bill. It is about the designation of stablecoin entities. I'll give the floor to the Hong Kong MA to take members through Part 3. Thank you. We've drawn reference from the relevant ordinance, that is the PSS VFO. Let's take a look at Clause 100. That is a prelude. It is not just applicable to individuals in Hong Kong, but it also applies to individuals outside Hong Kong or an entity incorporated or established in a place outside Hong Kong. Clause 101. MA may designate entity by notice published in the Gazette. The prerequisite is that the entity carries on a business outside Hong Kong of issuing specified stablecoins. And 2. Section 8 doesn't prohibit the entity from carrying on the business. Or B, if the entity provides, whether in Hong Kong or elsewhere, any services to a stablecoin payment system. So Clause 101 covers the entities mentioned in 1A and 1B. But there are considerations to be taken into account by the MA. That is, Clause 101, Subclause 2A, B, C. Is it material? Will it be material to the functioning of Hong Kong as an international financial center? Is it material to the monetary or financial stability of Hong Kong? Or is it a matter of significant public interest? And in bracket 3, what kind of directions that the MA may issue? Ms. Carmen Kan. Thank you, Chairman. I'd like to know the policy intent behind it. I'd like to know more about Clause 99. When the MA modify or waive any of the minimum criteria applicable in relation to the subject person, I am referring to C3387. Probably USDT, USDC, they aren't necessarily licensed. But what if the applicant is overseas? Well, what is the word you used? What if that person is subject to another regulator, then exemption may be granted. Now there's an equivalent regulator. If so, can you reduce the requirement or exempt the requirement? Not yet reaching Part 3. And in Part 3, it is applicable to individuals outside Hong Kong. I'd like to ask the administration the scope of the regulation. Just now we mentioned stablecoin issuers will have to register in Hong Kong. So before we dive into each provision, please tell us whom you would like to cover under Part 3. Thank you, Ms. Carmen Kan, for your question. For the policy intent of Clause 99, when there is a regulatory framework for stablecoins in all jurisdictions. And when the issuer comes to Hong Kong and applies to us for suitably modifying the minimum criteria, this ordinance may be invoked in making an application with us. And in accordance with Clause 99, Bracket 2, for regulators outside Hong Kong, they need to exercise a sufficient level of regulation. Just assume there are regulatory frameworks in different jurisdictions, then we need a mechanism for mutual recognition. Certain requirements will have to be met though. So when you take a look at different jurisdictions around the world, there are jurisdictions which can make an application under Clause 99. Is that correct? Well, we have EU, Japan, which have the stablecoin regulatory framework. There's currently none in Singapore, and the US is working on their own. We'll have to consider the requirements of different regulatory frameworks. Only then will we be able to tell whether the regulation is sufficient. Then we may proceed to consider the minimum criteria. Alright, let's go back to part 3. Just now we mentioned application, and it's not just applicable to companies in Hong Kong, it's also applicable to companies outside Hong Kong. Clause 101. The issuance of a stablecoin not pegged to Hong Kong dollars, then it cannot be covered by this bill. Clause 101, subclause 2, when it is material to the monetary or financial stability of Hong Kong, or when it is material to the functioning of Hong Kong as an international financial center, then the MA may appoint certain entities which will then have to meet different requirements. We'll come to that later. Thank you. Just now, Chris provided a clear explanation. Let me go back to Clause 100. Clause 100 provides that Part 3 applies to an individual or entity outside Hong Kong. In Clause 101, Bracket 2, however, the MA must not designate an entity under subsection 1 unless the MA is of the opinion that the issue of specified stablecoins by the entity or the provision of services by the entity to a stablecoin payment system is or is likely to become material to the monetary or financial stability of Hong Kong, or material to the functioning of Hong Kong as an international financial center. And Clause 102 explains what is to be regarded as material to the monetary or financial stability of Hong Kong, or to the functioning of Hong Kong as an international financial center or significant public interest. A. In the case of an entity it's about the handling, settlement, and transaction of stable coins. In B, On a normal business date, the total number of transactions, and so on. Clause 103. Well, excuse me, please pause right here. Member has a question.
括弧7
I'd like to ask about clause 1027 on the number of members of the public. How do you define members of the public? Can you really define it so clearly? Very often, users would be members of the public. We sort of inclining that there would be institutions that differ from members of the public. Well, I think you are correct. Well, first of all, we're talking members of the public refer to the public in Hong Kong, and it's just like an estimate because we would not know the specific number. So if you go back to 7 for the non-exhaustive list of factors that we would consider. So if there is a stable coin that is not issued in Hong Kong and not regulated by us, there would still be a method to define how many users there are and to look into the factors as to how many holders. So this is what we want to capture. Ms. Carmen Ken, thank you. I think we need to look into the legislative intent of Part 3. Well, we are now scrutinizing Clause 102, especially on relevant factors that could affect the stablecoin entity. Or you would consider the number of holders and also the estimated value. Well, I welcome what you're doing at the moment, but I want some sort of clarification. It's just like how we work with virtual assets. Here we are specifying the entities because for virtual assets we continue to develop, continue to change. Here, well, the physical entity could actually be overseas, but then it could be regulated as if it were an individual entity in Hong Kong. Well, we are going to go through the clauses one by one. In Clause 101, there is a mention that this can be providing payment service. And it can actually be an overseas entity that is providing payment service that is targeted at members of the public in Hong Kong. So it's just like how we can differentiate entities that are not set up in Hong Kong, yet they're providing services to those in Hong Kong. We see an occurrence with VAs earlier that well, if you're not regulated, then it's illegal. With a mechanism, then those service providers could also be regulated under our regulations. Well, of course, when we ask about the number of holders, it should be contextual because we don't know the specific number. However, we do not want to lose professional investors. When we discussed with the FSTB on regulation of VAs to allow professional investors to invest as well. So are you going to specify it for members of the public, and then when you are professional investors, then you would not have it specified? Would there actually be a room for flexibility here? Ernest, thank you, Ms. Khan, for your question. I think you are summarizing it better than me. Well, every day we use a Hong Kong dollar. When there is a remote possibility that we want to use something else, which is a stable coin, there would still be ways to regulate it. So we want this mechanism to have it regulated. As to when we decide to regulate it, then we would look at one factor, which is the number of holders. And secondly, we would also consider how large this group is and what the estimated value is. And there would be a way in which we could actually regulate it when needed. All right, Clause 103. Clause 103. The monetary authority can require information from officer if it has reasonable grounds to believe that an entity is an entity mentioned in Section 1011A. And Clause 104 on the designation of an entity under Section 101(1), the monetary authority may by written notice require the entity to provide the monetary authority with the following information, which is A, the names of the directors and shareholders of the entity, B, the name of the chief executive officer of the entity, and C, any other information about the directors, shareholders, and chief executive officer. The information must be provided within 7 days after the date on which notice is given, and where there is any variation, then the entity must, within 7 days after the date on which the change takes place, give a written notice of the change to the monetary authority. Clause 105. The monetary authority must maintain a register of designated stablecoin entities in the form the monetary authority considers appropriate and must allow the public to view it. Oh, I have a question on Clause 105. A register of designated stablecoin entities. Well, we want a physical register now, and this could be viewed by the public. Well, if everything is included in a chain and it's not a physical copy, would that suffice? Well, here we're talking about the register of designated stablecoin entities. We're not talking about the form itself. We are referring to the entity itself. The monetary authority, in accordance with Clause 101, has designated stablecoin entities which could be from overseas, and when the monetary authority deems it a designated entity, then this entity would be listed on the register, and this register could actually be viewed by the public and made available for inspection by the public. Ms. Carmen Can. Chairman, I have a question in relation to Clause 103. Of this high-ranking officer, well, here it is not yet licensed. As Ernest said, you're just trying to regulate it. When we refer to officer, are we referring to governors, a board of governors or directors? Well, there's actually a definition on that. You're correct. So the CE would be included. So under C1, you would see the director of the entity or any person involved in the management of the entity. Clause 106 empowers the monetary authority to revoke the entity designated, and Clause 107 requirements applying to a designated stablecoin entity. A designated stablecoin entity under bracket 1 must have in place operating rules for the issue of specified stablecoins by the entity on the provision of services by the entity to a stablecoin payment system, and that it must comply with any regulation made by the monetary authority under section 171, and 2, provide for the entity to be operated in accordance with this ordinance, and 3, provide for appropriate and adequate arrangements to deal with a situation where the entity is likely to become unable to meet its obligations. It also says that a designated stablecoin entity must maintain appropriate and adequate financial resources, and in accordance with bracket D, have in place and implement appropriate and adequate systems of control for reserve management, disclosures, and risk management. All right, part 4. Part 4, functions of monetary authority. This lists out the functions of the monetary authority. Clause 108 lists out the functions of the monetary authority, including specific functions. A, to supervise compliance with this ordinance. B, to promote and encourage proper standards of conduct and operation and sound and prudent practices among licensees. C, whenever appropriate, to cooperate with and assist financial services supervisory authorities of Hong Kong or elsewhere in regulating, supervising, and overseeing matters related to specified stablecoins to the extent permitted by this ordinance or any other ordinance. E, to suppress or assist in suppressing illegal, dishonorable, or improper business practices of licensees, and to take all reasonable steps to ensure that regulated stablecoin activities carried on by a licensee are carried on with integrity, prudence, and the appropriate degree of professional competence, and in a manner that is not detrimental or likely to be detrimental to the interests of the holders or potential holders of specified stablecoins. Mr. Chen Zhenying. Thank you, Chairman. Clause 108, bracket 1. I believe that the English suffices, but then for Chinese, it says 應付關乎指明穩定幣的風險. I believe that 應對 is a better term than 應付 in the Chinese version. Thank you, Chairman. We would bring this back and consider it. All right, Clause 109. That the Chief Executive having the power to give direction, and it must be made in the form of writing and be in the interest of the public. Clause 110. For the better performance of the monetary authority functions under this ordinance, the monetary authority may by written notice require licensee to provide with any information or document relating to any of its business activities, and if that is not provided, that would be liable to an offense. Clause 111, to give authority for the monetary authority to examine books and accounts, etc. Clause 112, empowering the monetary authority to require a report to be prepared by a skilled person. Clause 113. On specified person can only be appointed as a skilled person to prepare a report acquired under section 112 bracket 1. A person who is approved by the monetary authority under subsection 2 for preparing the report, or nominated by the monetary authority under subsection 3 for preparing the report. The monetary authority may approve a person for appointment as a skilled person to prepare a report, or the monetary authority may, for the purposes of subsection 1b, nominate for appointment as a skilled person a person that the monetary authority considers to have the necessary qualifications, skills, experience, and resources to prepare a report. Clause 114, empower the monetary authority to impose requirement on skilled person or specified person. A specified person who fails to comply with the requirement commits an offense.
指示某
Alright, Clause 115. It empowers the MA to direct licensee or designated stablecoin entity to take any action to bring the licensee or entity into compliance with the bill. Subclause 1. The MA may, by written notice, direct licensee or designated stablecoin entity to take any action that the MA considers necessary for bringing the licensee or entity into compliance with this ordinance. And a direction given under subsection 1 must specify the action to be taken and must include a statement of the respect in which the MA considers licensee or entity not to be in compliance with this ordinance and may specify a period within which the licensee or entity must comply with the direction. Moving on to Part 5, Investigation. Part 5 provides for the institution of an investigation by the MA. Clause 116, investigation by the MA. Including an offense under this ordinance may have been committed by a person, or a requirement imposed by or under this ordinance may have been contravened by a person, or C, a condition attached to a license, consent, or any other instrument granted or given by the MA. Ms. Carmen Khan, well, before moving on to Part 5, I'd like to go back to Part 4. It's about the functions of the MA. Basically, by defining specified person, say in Clause 111, specified person refers to the licensee or the stablecoin entity. And that is about the functions of MA. The MA can manage the relevant specified person under different clauses. And I can see the term stablecoin entity. Just now, Chairman, you mentioned the register. It enables the public to know what overseas entities are specified to be a specified stablecoin entity. Despite the fact that it is overseas, in the course of transactions, members of the public can access your website or your register. And then members of the public will know the issuers or the stablecoin entity are under your radar. Apart from this method, is there anything that the public can do to access information, for instance? When you send directions, entities need to comply with your directions. Do we need the entities to be companies registered overseas, say Part 16 of the Companies Ordinance, Companies Registration Ordinance? There is sale to the public, so does it require Part 16 registration in accordance with the Companies Ordinance? Just now you mentioned we need an enforcement mechanism. There is no requirement as to a fit and proper person, so what is the line of logic right here? Thank you, Chairman. Thank you, Ms. Carmen Khan, for your question. The specified stablecoin entity has requirements to comply with. Say, in Clause 107, there are requirements applying to designated stablecoin entities. And a designated stablecoin entity isn't confined to those in Hong Kong. Apart from those in Hong Kong, it is also applicable to those outside Hong Kong. From the perspective of regulation, it may not be that exhaustive, but because we need to protect the public, so stablecoin entities specified by the MA need to comply with the requirements. Well, I understand. I know you want to regulate these stablecoin entities. Oftentimes, these entities issue stablecoins online on blockchain. From the perspective of filing tax returns, well, Part 16 of the Companies Ordinance refer to overseas companies that can transact business in Hong Kong, otherwise they may seem all too remote. I'd like to supplement. We don't require the companies to be registered in Hong Kong. The policy intent is, as Ernest has given us an example, for overseas stablecoin issuers, if the stablecoins are commonly and widely used in Hong Kong, there is a risk to the financial stability of Hong Kong. That's exactly why we want to impose requirements to make sure the day-to-day operation meets our basic requirements. We don't require any establishment of offices in Hong Kong. We don't require officers to be stationed in Hong Kong either. Well, now that these entities sell stablecoins to Hong Kong, from the perspective of filing tax returns, they may make profits in Hong Kong. If you don't require any Part 16 of the Companies Ordinance, well, I can see the DS thinking about this issue. If no BR is required, is it the case that they aren't doing business in Hong Kong? Is there any test, any permanent establishment? Is this the criterion we are using? If so, then we are rather strict. We are less lax, then we can protect investors. You need to be able to get a hold of the stablecoin entities. The essence is not to require establishment of the office in Hong Kong. When a company or when an entity is not registered in Hong Kong, they obtain BR through Part 16 of the Companies Ordinance. They have presence in Hong Kong. From the perspective of filing tax returns or regulation, will you consider regulating these entities? Well, in the future, the MA may issue directions or guidelines in relation to stablecoin entities, and it will detail our considerations in due course. Thank you, member, for your view. We'll consider your view seriously. We still have some time. Let's continue. Clause 116 empowers the MA to institute an investigation in certain circumstances. And the person will have to submit the document when required. 117, power of investigator to require production of record or document, and the person so required will have to provide record or document. 118, power of investigator to require answer, etc., to be verified by statutory declaration. That is, the investigator may by written notice require a person to verify by statutory declaration the answer, response, explanation, or particulars, and he or she needs to do so within the period specified in the notice. Clause 119, report by investigator. An interim report may be given to the MA on the investigation. Clause 120, offense for contravening Section 117 or 118. A person commits an offense if the person, without reasonable excuse, fails to comply with a requirement imposed on the person under Section 117, brackets 134, or Section 118, brackets 1 or 2. Clause 121. Court of first instance inquiry into failure to comply with requirement of investigator in relation to Section 117 or 118. The investigator may apply to the Court of first instance for an inquiry into the failure, and the CFI may order that the person to comply with the requirement not complied with earlier. If the person doesn't comply with the requirement without reasonable excuse, then that person may be found guilty of contempt of court. Clause 122. Well, Mr. Benson Loke, let's pause at Clause 121. From Clause 116 to Clause 122, all about investigation. There's the term investigator. And in Clause 116, brackets 2b, with the consent of the Financial Secretary, by appointing in writing one or more other persons to investigate the matter mentioned in that subsection. I'd like to seek clarification. Are investigators in the establishment, or are they appointed when an incident arises? What is the mechanism? Thank you, Chairman. Thank you, Member. Indeed, Clause 116, subsection 2b, that is the person appointed under the Exchange Fund Ordinance. We have a team of officers responsible for conducting the investigation. Regarding B, this is a special circumstance, and the Financial Secretary will have to appoint in writing one or more other persons to investigate the matter. Well, let's pause at Clause 121 in the interest of time. There's no other business. The next meeting is scheduled for the 24th of March from 9 to 12. Meeting adjourned. Thank you, members.